Hey, it's Terry Gorry, and this is the Irish Law and Small Business podcast. Usually you'll see when an employee appeals the outcome of a disciplinary, some sanction will have been imposed on the employee, and he may be looking or she may be looking to have the sanction either removed completely from the record or reduced to a lesser sanction. But I came across a very interesting case there the other day. I've written a blog post about it, and you can have a look at it on my website, employmentrightsireland.com. But it's about an employee who actually appealed a final written warning against him, and the outcome of the appeal was summary dismissal for gross misconduct. That's quite unusual. You don't often see that. As I say, you see the employee either not having the appeal upheld or else having the appeal, the sanction rather, reduced to a lesser sanction. This particular case involved is called Martin Brown and Aegis Road and Tunnel Operations Limited. Aegis Road and Tunnel Operations Limited operate or are the operators for the Dublin Port Tunnel and the tunnel in Cork. Martin Brown was a duty manager in the tunnel control room at the Dublin Port Tunnel. In January of 2018, a prank was played on one of the tunnel workers by a work supervisor, or by a toll supervisor rather. And the supervisor told the worker that there was a serious accident in the tunnel. And the worker then, the colleague, took off and put on the flashing lights on his car, etc., and rushed into the tunnel to see how he could render assistance in the accident. When he got back onto his toll supervisor, he couldn't find the accident. The toll supervisor said that you'll find it because there's debris all over the road or something of that nature. This was a prank. And the employee who was sent out on the wild goose chase, as it were, didn't take kindly to it and made a complaint about the toll supervisor. An investigation was carried out. The outcome of the investigation was that the toll supervisor admitted he had pulled an ill-thought-out prank. And one other finding was that Martin Brown appeared to be involved in the incident and did not intervene. And remember, Martin Brown was the manager. He had ultimate control of these employees and this particular situation. The matter was put forward for a disciplinary hearing. Martin Brown complained about the use of CCTV in the disciplinary because he correctly argued that there was High Court authority that you couldn't use CCTV in disciplinary if the purpose of the CCTV was for some other purpose, for example, health and safety. Nevertheless, the company went ahead, and the outcome of the disciplinary was a 2-week suspension from work and a final written warning. Martin Brown then appealed the outcome of the disciplinary with the assistance of the union in the workplace. The appeals manager found that the final written warning was not the appropriate sanction, but increased the sanction to summary dismissal, having regard to all the circumstances, having regard to the disruption that was caused in the tunnel, taking into account Martin Brown's responsibilities and the role that he had and the duties and the fact that he was a manager and so on. Martin Brown then appealed this decision ultimately, or brought a claim rather, for unfair dismissal and for non-payment of wages to the WRC. He was arguing about non-payment of wages. That was actually the wrong claim. He should have brought it minimum notice. He was arguing that he wasn't getting paid for the notice period and he was there such a long time, etc., etc. The outcome of that particular claim, however, was that if you are summarily dismissed, you're not entitled to notice. So that went down the tubes. He brought a claim also for unfair dismissal. He was seeking €86,000 for loss of earnings because this arose over the following 2 years after his dismissal. He had originally been on a salary in the Dublin Port Tunnel employment on 64 grand a year, and he had to take a new job with a lesser salary of 42,000. The WRC decision then, the adjudicator pointed out that the job of an adjudicator is not to establish guilt or innocence of the employee. The job of the adjudicator is to ascertain and decide whether the employer's response fell within a range of reasonable responses. Authority for this proposition comes from a case called the Governor and the Company of Bank of Ireland versus James Riley. It's a 2015 case. So it's clear that the onus is on the employer to establish that there were substantial grounds justifying the dismissal and that it resulted wholly or mainly from one of the matters specified in Section 6.4, subsection 4 of the Act. This includes the conduct of the employee. The adjudicator looked at the procedural framework as well that was used to arrive at the decision. In other words, did Mr. Brown get fair procedures and natural justice? Was the process fair? The adjudicator said that it's not the function of the court to form a view on the merits of complaints, but rather to allow the employer make a decision and decide then whether that response, the decision of the employer, fell within a range of reasonable responses. In relation to question of fair procedures and natural justice, the High Court in a case Short versus Royal Life Insurance outlined that the central consideration to a fair process is whether or not any purported breach of natural justice was likely to imperil a fair hearing or a fair result. This essentially means that the employer doesn't have to be perfect. The employer's process doesn't have to be perfect, doesn't have to be free from imperfections or infirmities. The employer's process, however, must be fair. In this situation, in this process, the adjudicator recognised that there may have been some imperfections, but bottom line is the overall process was fair. So in looking at the reasonableness then of the response of the employer, there's three questions to look at. One, did the company believe that the employee's conduct or misconducted himself as alleged? In other words, was there misconduct? Two, if there was misconduct, did the company have reasonable grounds to sustain that belief? And three, if so, was the penalty of dismissal proportionate to the alleged misconduct? They are the three questions that you must look at when you're judging the employer's response in a situation like this in a disciplinary. The adjudicator found that in all the circumstances, the employer's decision to terminate the employment summarily for gross misconduct was reasonable, and an employee who was dismissed for gross misconduct is not entitled to notice. Therefore, his claim for payment of wages wasn't upheld either, and it was thrown out. So there you go, an appeal that ultimately went pear-shaped and ultimately saw the final written warning being increased to summary dismissal and the termination of the employee, and the employee has lost his case at the WRC. I don't know whether he's going to appeal it to the Labour Court or not, but that's the decision that's been published there in the last few weeks. It's an interesting case. You can have a look at the blog post, but more importantly, the actual decision. There's a link in my blog post on my website, employmentrightsireland.com. There's a link to the actual decision from the WRC. There's a lot in the decision. There's a lot of evidence given by various parties to the investigation into the incident in the port tunnel and so on. So it's interesting. It's worth a read.